Good afternoon, everyone. I'm Tara Lyons. I'm joined by Samara Brackley, and we are going to be speaking today about cohabitation when children are involved. And in particular, we're going to look at some case studies. So we're going to have a look at what happens when you just have a pure TOLATA case or Schedule 1 case, and what happens when you've got a combination of the two. We'll do a quick recap on the procedure, but the focus of today is going to be on these case studies because we think that that way will give you some practical tips on how to approach these sorts of cases. So as the slide says, are you sitting comfortably? And we'll begin.
So what is the legal framework? We're not planning on spending too much time on this because hopefully you all have attended Mark's seminar last week, which will have dealt with the bulk of this, sort of an introduction to these sorts of claims and what the legal framework is. But just to recap for anybody that did not attend that, under TOLATA, the Trust of Land and Appointment of Trustees Act 1996, the key sections that you're going to need to be looking at if you're making an application under this piece of legislation are sections 14 and 15. We've got section 14.2 there, which sets out effectively what the court is able to do under TOLATA. So it can exercise the power of the trustee or trustees, apart from appointment or removal. And then we've got declarations as to the beneficial interest in the property. And this is the section to use also if you're applying for an order for sale of the property, which is probably one of the most common reasons that you would be using this particular piece of legislation. Section 15.1 then sets out the factors that the court will be considering under an application under TOLATA. So that's the intentions of the settlers, the purpose of the trust, so the purpose the home was bought in this particular context, and the welfare of any minor child if they are in occupation or they're reasonably expected to occupy that property. So again, in this context, if it's been bought as a family home, children are still living there, that's going to be something that the court will consider. And then the interests of any secured creditor. And then dealing with Schedule 1 to the Children Act, I suspect this may be a little bit more familiar to our audience, but just to run through this, particularly because there is a distinction between what you can apply for under Schedule 1 and what you can apply for under the Matrimonial Causes Act when parents of children are married. So we've got child prodigal payments and secured child prodigal payments. This is not a talk about child maintenance and the CMS jurisdiction and various other issues, but the jurisdiction is there to apply for child prodigal payments if it applies to your case. You can have multiple lump sums in Schedule 1. So that isn't sort of a one and done application like it would be under the Matrimonial Causes Act. So multiple applications can even be made in future for further lump sums if you didn't receive enough in your first application, or if the needs of the children have changed, for example. And then we've got transfer of property and settlement of property. But as I'm sure many listeners will know, this is really on a reversionary basis only. So it's to do with buying a property or securing a property for the purposes of the children, but that would usually revert to the person that's provided the money upon the children no longer needing to live in the property. And all of that, anything that you're seeking under Schedule 1, any part of your shopping list, it must be evidence to be for the benefit of the child or the children involved. So what can't you do? You can't have an order for sale of property. So if you are seeking a sale of property, that application needs to be made under TOLATA. You can't have any order for the benefit of the applicant parent alone. So there can't be any applications for things that would be for the sole use of one of the parents. They don't have their own claim. It's really for the children. And you can't have anything involving pensions. We'll come on to this, but the disclosure that you would do under Schedule 1 doesn't typically involve disclosure of pension assets or business assets anyway. So you can't have any pension sharing orders.
That's not to say, of course, that the family court in particular haven't come up with creative ways of deciding what's for the benefit of a child. I mean, we see that, don't we, with HEXA, which is a broader type of maintenance payment to cover the costs of the caregiver, and also, the meeting debt, meeting the cost of a car, etc. So although far more limited than the Matrimonial Causes Act, creatively they found ways through.
I think what I tend to say to clients actually is that it's sort of a needs plus way of looking at things. And obviously that will depend on the lifestyle and their, what funds are available, etc. But it does fundamentally have to be something that's got some link to the benefit of the child. So yeah, cars, etc., all permissible, but you've got to sort of prove, I suppose, that it's going to be a car that's going to have some benefit to the child, taking them to school, I suppose, that sort of thing.
So I'm going to just speak very briefly about disclosure. When you're dealing with Schedule 1 claims, of course, we're using the Form E1, which doesn't have the boxes that we'd see in Matrimonial Causes Act applications, financial remedies applications regarding businesses or pensions. Form E could be more appropriate where a party has wealth tied up in a business or a SIP structure, but you'd obviously have to justify that to the court. Even if a party is running the millionaire's defence, i.e. I'm so loaded I don't really need to tell you very much, they've still got to provide the information by their Form E1 with an overview of the assets and broad values, and that was made clear in the recent case of YNX 2024, and you've got the reference there. And of course, you can always ask for further disclosure through questionnaires and replies. Slightly different when we're looking at TOLATA cases. So disclosure in TOLATA cases is governed by Part 31 of the CPR, and it sets out the detailed aspects of disclosure. In most TOLATA cases, you're usually dealing with standard disclosure, which is generally provided by way of list, and then there's provision for inspection. But for reasons of proportionality, the court could depart from that requirement. And actually, I find that in a lot of cases where you've got Schedule 1 and TOLATA together, it's dealt with in a really abbreviated way because they've got the questionnaire, and that's sort of considered enough in a lot of cases. So let's have a look at our first case study. And while I'm doing that, Samara, can you check the chat?
Yes.
Because I want to check there are no issues with anyone hearing us. And as I didn't say, yes, someone said, do we get these slides? We're very happy to send out the slides afterwards. And please, if you have any questions as we're going along, just stick it in the chat. We'll try and check it periodically and deal with any questions at the end if we have time. So please do communicate with us by the chat function on your screens. Great. So, Miss Goldilocks and Mr. Bear. Forgive the parties' names, but we thought it brought a little bit of lightness into it. So Miss Goldilocks and Mr. Bear have been cohabiting for 12 years. They separated 5 years ago. They own a 4-bedroom house together at 2 Porridge Way, worth 700,000. There's equity of about 500,000. Joint legal owners, but they forgot, that's certainly what Miss Goldilocks says, to have ticked the box on TR1, which sets out any express declaration of trust as to the beneficial ownership. And there are 2 children, 8 and 12. They spend broadly equal time with the parents. Miss Goldilocks and Mr. Bear earn practically the same income, and that, of course, means they've got practically the same mortgage raising capacity of about 500,000 each. Miss Goldilocks has remained living in the property. She pays 50% of the mortgage, and she also would like it taken into account that she's paid £20,000 for a new kitchen, which she says has increased the value of the property. Mr. Bear has continued to pay, to his credit, the 50% of the mortgage repayments, as well as having to pay his own rent on the property he has tenanted for the last 5 years. So Mr. Bear, who paid more towards the deposit some years ago, says he would like to have a bigger share of the property. He says he paid more towards the mortgage as well, and he thinks it was always intended that the parties would own the property 60-40 in his favour. He'd also like to be compensated for the amount he's paid on rent since separation. Miss Goldilocks says, no, 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 this was always intended to be our family home, and we always intended to own it equally. She would like to be compensated for the work she's done to the kitchen. So, first things first, when you get a case like this on your desk, what are the possible claims? Now, it seems to me that this is going to be a very TOLATA focused case, and the principal issue is going to be how do these parties hold the property beneficially? And the claim is going to be for a declaration of trust. Additionally, there are some equitable accounting claims, possibly an occupation rent claim by Mr. Bear, and Miss Goldilocks seems to be wanting an equitable account for her refurbishment works. And if it's not agreed, there will have to be an order for sale. At the moment, it looks unlikely that there's going to be a Schedule 1 claim. So what are the next steps? I think it's fair to say that when you have a TOLATA claim in which the beneficial interests of a property is in dispute, there is a huge amount of front-loaded information gathering. And that is something that really you can't short circuit. And it's the cases that come across my desk where it has been short circuited that are the cases that really go disastrously wrong. The cases where it's been taken all the way to the final hearing or trial and no one has even obtained the conveyancing file, which is going to be the most insightful lot of documents relating to the intentions the parties had at the relevant time as to ownership. So I always say, as a matter of sort of habit, when you've got a case like this, first things first, get the conveyancing file. And we all know, don't we, that there's a time pressure on that because of the length of time that solicitors' firms may hold those files for. So you need to make sure you've asked for it at the earliest opportunity. It's not always available, particularly with those older cases. And so the next best thing, and the thing that I would always suggest you ask for, is any correspondence between the client, your party, and the other side at the time of purchase, and or their solicitors, because that may not obviously be the whole file, but it might be enough to give some indication as to the parties' joint intentions, particularly if they were CC'd on the same email. And I also think asking about, well, did you have a financial advisor at the time? Did you have a mortgage broker? Those sorts of communications as well. Any communications with third parties such as that can also be revealing. So think outside the box and ask for those communications. Text messages, we don't want our clients sending us reams and reams, but sometimes they can contain a golden nugget. And I would always suggest you get them to have a little look through, if it's WhatsApp, they can do a search fairly easily, can't they, for trigger words. And in this case, you probably, if you're representing Mr. Bear, you're going to want him to provide evidence of his greater deposit. You're going to want him to provide evidence of the mortgage payments. So you'll need to get bank statements, and they can be very revealing. If you're for Miss Goldilocks, then some evidence that she's paid for the work, some before and after photos. But the key thing with that is going to be the impact on the valuation. You'll want to get some consensus early doors about the valuation of the property and any increase in value by way of the kitchen works. And given the occupation rent, you'll want to get some advice from a estate agent saying what the market rent is for the property. So as I've said, fairly front-loaded, but necessary before you can start making reasonable proposals or offers.
Something I would just add about this is that I had a case where there was a lot of dispute earlier this year about who had paid what in terms of the mortgage, because somewhat unusually, the parties had actually set out their mortgage contributions within their declaration of trust. And so there was an argument as to whether they had actually been contributing the percentages that they were supposed to be contributing. And the other side, on the day of the ENE FDR that we had set up, PFDR, the other side turned up with a lever arch file about that big of bank statements. And obviously nobody went through it at that point because it just wasn't proportionate. So it's one of those things where absolutely it's a lot of work, but it needs to be front loaded because you can't just turn up on the day that you're supposed to be having a constructive indication given and just say, by the way, here's these 10 years or so of bank statements that I want you to look through.
Yeah. And I would just say, and I mean, I think it's really, really important to say, we as advisors know that really the only sort of situation you're going to get an equitable account claim off the ground is really post-separation. So, and you'll have to advise your clients about the prospects of getting anything earlier being slim to none, unless it's like Samara's case, in which actually the deed itself provided for a certain contribution and then that wasn't adhered to. In that sort of situation, you might have a stronger claim, but it is important to be proportionate. But if you are going to run an equitable account claim post separation, then you've got to do the hard work and get the information as early as possible. First things first, once you've got enough of the information to properly put forward your case, please remember that under the pre-action protocol, you have to write a letter of claim, and that letter of claim has got to comply with the practice direction pre-action protocol. It's often quite a detailed, long letter. I have seen on occasions a so-called letter of claim that's just a page and a half long. That indicates to me that it probably doesn't include all the information that is required. You've got to set out the background facts. You've got to set out the bases of claim. And I always think actually it's a lot more akin to a particulars of claim that's been put into a kind of succinct narrative rather than a kind of shortened letter. So it can't just be the summary, and it's the first document that really starts to incur the kind of cost consequences and set out your party's case. So it's important to get that right. As we say there, it is open correspondence, and I have landed costs sanctions effectively from a letter of claim that didn't set out a party's case accurately or correctly. So that is important to get right. It's a really important mechanism for requesting the disclosure that you need. So as well as providing all the documents that you think are relevant to your claim, have a good think about what you'd like from the other side, whether it is, the evidence that Miss Goldilocks paid for, her invoices, or the evidence of the bank statements showing that she paid the 20 grand towards the kitchen, or whether it is for Mr. Bear, Miss Goldilocks evidence of what she says the intention was at the time. Ask for that early doors, and please always include an offer of ADR. Whilst technically that doesn't have to be mediation, as I'll go on to talk about, it is best practice, I think, to offer mediation, and I'll explain why in a minute. So after receiving your letter of response, you go off to get advice from counsel, who advise that Mr. Bear will more likely than not fail on a claim for 60/40 beneficial interest. The court is likely to award 50/50, but he has a reasonable prospect of succeeding on an occupation rent claim of about 15,000. Miss Goldilocks has a chance of succeeding on the claim for equitable account, but only in the sum of 5,000. An order for sale is inevitable. Once you've got that offer in, if you haven't done it already with the letter of claim, and I think it's good practice to always think when you're drafting your letter of claim, can I accompany this with a Part 36 offer to give my client the best cost protection? It's really important once you've got advice from counsel or feel more confident about the direction of your case to make a Part 36 offer as early as possible. Part 36, it's got to comply with the requirements of Part 36. Please always have a rereader section, use the pro formas.
It's quite user friendly, actually. It does set out in terms of step by step everything that needs to be in it. And if you're worried about whether your Part 36 offer or letter does not include the relevant sections, just quote the sections from the CPR. Just say, as per this, particular procedural, as per this particular procedural, to make sure that you've covered it all off.
And also just always put in there, if the other side thinks there's any reason this doesn't comply with Part 36, please let us know. And then you're putting them on notice to flag something early, which then gives you an opportunity to rectify it if needs be. Obviously, because Part 36 comes with the cost consequences, and I know you're going to have a more detailed session on costs later down the line. So we won't go into it, but obviously because of the cost consequences of it, you're more likely, if it's at the right level for it to be accepted, it's essential that you pitch it correctly. And I think a lot of this, Samara and I were talking about it before we kind of came online actually, and we were talking about really the key thing is getting a sense from your client and the correspondence to date as to how likely it is that the other side are also going to engage with the ADR and or attend mediation. Because if you're for Mr. Bear and you know that Goldie, as we refer to her for short, Goldie's going to come to mediation, she's fairly reasonable upon advice, then you don't want a Part 36 and give yourself no room for manoeuvre at the mediation. So it's got to be generous enough to Goldie on the declaration of interest or declaration of beneficial interest that it gives you some cost protection, but not so generous you're basically giving her your bottom line, because otherwise mediation means she can just use that to reduce your occupation rent claim and increase her equitable account claim. So if you are for Mr. Bear and Mr. Bear says, look, Goldilocks is a really tricky character, she's not going to mediate, she's not going to move out the property, she's going to fight this the whole way, I'd be far more tempted to make a 50/50 offer out the bat, early doors, and perhaps give yourself some shades of movement on the occupation rent and refurbishment claim, but giving yourself that protection so that really she's under real pressure to then engage with your other offers. I think if actually we think Goldie's going to be reasonable, she's going to attend mediation, she is going to engage, then in that sort of situation, I'd probably be saying, well, why don't we start off with a 57.5% share to Mr. Bear and move down from there so that you've got more chance of doing better on your equitable accounting claims. If you're for Goldilocks, of course, you want to go for the 50/50, and you could probably go in with your equitable account claim.
For the kitchen.
Yeah. So ADR, I said I'd come back to it, and the main reason that I just want to focus on it is because I think sometimes us as family lawyers can view mediation in a slightly different way. Now, under the CPR, if a party fails to engage in ADR, then there are quite severe cost sanctions, and the civil courts routinely impose those cost sanctions. Annie's going to give a detailed talk on it, and I'm sure she'll touch on that in due course. So you've just got to make sure that you are not unreasonably refusing or engaging with a request to mediate on behalf of your clients. And when we're talking about mediation in the TOLATA context, we are talking about a civil style mediation. So your sort of old-fashioned shuttle mediation, conducted by someone hopefully who has a lot of experience in TOLATA cases, and they can be really, really effective. I kind of think actually when you've got a pure chancery practice or come from pure chancery practice, you sort of treat the civil style mediation a bit like the private FTR. They are as effective. Most cases settle at mediation, if not soon after. So they are an important thing to get right. Really important to get your mediator right. Really important to get the timing right. But if you arrive at your first CMC or directions hearing at the court and you have not engaged in mediation, I think that is something that you need to be very wary of and avoid at all costs. So if you don't settle at mediation, if you're in that minority, what next? Well, you've got to think about issuing the claim. And really important thing to remember, it's got to be to a county court. It cannot be a pure family court. So you can't issue your TOLATA claim in the CFC, for instance. You need to have your eye on the CPR, not FPR. And the first thing you're going to have to think about is, am I issuing this by Part 8 or Part 7? The general rule is that if there's any significant dispute of fact, it's Part 7, and you probably want to go down that route because you want the other side to pin their colours to the mast in their pleadings. And it's quite easy, isn't it? When you think about Part 8, it's just a witness statement with the details of claim in the N208. It's quite easy actually to avoid having to set out your case in any great detail in Part 8. You can sort of fudge it. So if you think you've got a strong case in particular, I would be saying you want to towards Part 7. It's usually those cases where it's a straightforward sort of issue about the mechanics of a sale. Should there be a sale or not?
Yeah.
Or, maybe a very straightforward equitable accounting claim where you might get away with a Part 8.
I think this case is definitely a Part 7.
Yes.
Because of the dispute between the two of them about the beneficial interest. So that's pretty much automatically I'd have said it's going to be Part 7. But
Yeah.
Part 8, in my experience, as Tara says, is just the parties can't agree on an order for sale. Either there's a declaration of trust or they've ticked the relevant boxes in the TR1, so ownership is obvious.
Yeah.
And it's just then dealing with one party doesn't want to sell, one party does want to sell, and what we're going to do about that. And that's your standard Part 8 case. But Part 7, with Mr. Bear and Goldilocks, that's definitely going to be the route that you're going down. So as Tara says, that's proper pleadings. You will have to do a proper particulars of claim and a proper particulars of defence if you're acting for the defendant. And it is more procedurally involved, particularly because to do with precedent H, etc., and the various bits of cost budgeting as well.
And if you're in any doubt, let's say on this case, just before we kind of move on, let's say on this case, actually, Mr. Bear thought to himself, well, it was, of course, we always intended 60-40. We had these conversations. I can't believe that Goldilocks would say anything differently. And there's strong evidence. What you might want to do is put Goldilocks to task in the letter of claim and set out that given the evidence, which is sort of incontrovertible, it's clear it's a Part 8 claim. Do you agree? If not, please set out the reasons why. So you're basically putting the onus of trying to persuade the court otherwise on Goldilocks early doors, really for cost reasons, so you can justify why you're making it Part 7 in due course.
We've just had a couple of questions in that's probably best to deal with now before we move on. One of them is to do with where there's a background of domestic abuse. Could an open offer of arbitration in place of mediation be said to meet the requirement to attend ADR? What I would say first off is that there is unfortunately just very little protection, very little consideration really for victims of domestic abuse under TOLATA. I was part of the resolutions working group on economic abuse with the report that was published, I think, actually just about a year ago. And the responses to that survey were effectively that those of you who may have responded said there isn't really any degree of protection. I think it was 92% or something said that they felt that there wasn't enough protection for victims of domestic abuse in TOLATA. You absolutely can go to arbitration, but as Tara said, traditional civil mediation is a shuttle form of mediation. So they would be attending, both parties would be attending in different rooms with their lawyers. The mediator would go between the two rooms, and there would be absolutely no reason for the parties to interact. No. So in those circumstances, I would have thought that you would probably want to suggest mediation, but just with some protection for the vulnerable client in terms of perhaps different entrances, making sure that there are definitely different toilets available, that sort of thing, so that they don't come into contact with one another. Make the mediator aware that so far as your client is concerned, that's the background to this. And so delicate handling might be appropriate, but that also might feed into your choice of mediator, to be honest.
I think that's a really good point. And I think that the key difference when you're thinking about civil style mediation, or what I think conventionally is known in the family world as sort of hybrid mediation, is actually, particularly on the civil side of things, the amount of mediations I've been to where we have a joint or open introductory session, it is slim to none. I mean, they just sort of don't happen anymore. So you could say, look, this isn't going to be a case for obvious reasons where there'll be any joint session. And then it literally is reduced to the shuttle mediation, which is very, very, very effective. They're accompanied, it is lawyer led, it is lawyer accompanied. And that, again, I think makes it actually quite conducive to cases where there is a background of DV. It's not at all like the family mediation where the parties are just left to get onto it. I think that would arbitration count as ADR? Well, it definitely would, because I mean, the point is, if it's an arbitration, you would have the answer, you would have the award, that would be it, and that would have settled it. So in a sense, the costs arguments there just wouldn't really come into it. Where I think it gets more sticky is if you have done nothing pre-action. So, if actually the arbitration takes place after you've had your CMC through the court process and it's just in place of a trial, then no, I don't think you've had enough cost protection. And whilst ADR, of course, also includes making offers, what I've found from the cases and from my experience is what the court really wants to see is either mediation or some other form, let's say an ENE early and pre-issue. It's a fact of having it pre-issue, I think, that's going to be so important. Other question, do open offers made outside Part 36 offers to ameliorate costs, risks in any sense? Do open offers made outside Part 36 offers to, I don't actually think I understand that question. Do you, Samara?
Not entirely. I think
might be a word missing.
I think we'll move on, and then if the person that asked the question wants to retype it, I think it's getting at, is there any point in making an open as well as a Part 36? But we can deal with that. But
I think on the TOLATA point, you might want to make some open concessions but I don't actually think this is a case that would cry out for it beyond, and I'm sure you could get enough cost protection with the Part 36 in this case. Anyway, claims been issued, allocated to the multi-track by default. All of these claims are.
Yeah.
And the first hearing you would usually have, so this is just pure TOLATA, we're not dealing with a Schedule 1 that's in the mix, would be a directions hearing. Now, that is quite a good opportunity for you to actually try and force the other side to attend mediation. And judges are always willing to accept invitations to stay a matter for the purposes of mediation, and you can put in the sort of standard wording about that, so that if then the other side doesn't play ball, you could use that as an example of not reasonably engaging. Then you're dealing with other directions, disclosure statements, expert evidence, etc. And I've set out here quite a useful and underrated part of the CPR, which allows the court to actually case manage in a private FDR or E&E. There is no power, an E&E, there's no power for the court to require the parties on a TOLATA case to attend an FDR unless by consent. There is, however, pursuant to CPR 3.1.2m, power for the court to list an E&E, a court-led E&E. And obviously, if you're in a situation like, let's say, Goldilocks in this case, who on the law is likely to achieve her 50-50, you're going to want to push it to an E&E type solution, because you're going to want something that basically shows that you're right on the law to engage, to force Mr. Bear to come to the table. Thereafter, you have the CMC. More often than not, they're sort of actually kind of conducted as quasi FDRs, an opportunity for the judge to try and help the parties settle. And if that fails, then it's on to a trial. And remembering, particularly with those high net worth clients, that actually these are public hearings and there isn't the anonymity, and anyone can show up in the court itself. So that's a reason, going back to the arbitration point, where you might want to contract out of the court proceedings, because there's no getting around it. Couple more words from me. Cost budgeting. You've got to deal, when it is a cost budgeting case, with precedent H. That's not the family form H. That's a really serious because there are sanctions if you fail to produce it. You've got to apply for relief from sanctions. It's a serious document estimating all of your costs to take this to trial. Counsel's fees, instruction of experts, conferences, time spent on reviewing documents, etc. And it's a lot of work, but it's got to be done in those cases where the court says it's got to be done. Costs, again, you're going to hear on costs more, but usual rule is costs follow the event. Quick word here, there is no power under TOLATA cases or applications for the court to make either a costs allowance or make interim provision. So it struck us when we were thinking about this case of Mr. Bear and Goldilocks that it might be, for tactical reasons, if Goldilocks, for example, wasn't in work at the time and had no income and no savings to speak of, that even if it wasn't the strongest Schedule 1 claim, you might consider making a Schedule 1 claim at the same time if she required interim support in that way. So just something to bear in mind.
Yeah. Moving on to our next case study. So we've got, again, sorry for the fictional characters, but we've got Anna and Christoph. They've been in a relationship for 10 years and they have 3 young children together. 5 Snowy Lane is their home, but it's owned in Christoph's sole name. So Anna isn't on any of the legal documentation regarding the ownership of this property. It's worth around £900,000 and there's a net equity of £600,000. So the mortgage is in Christoph's sole name. Christoph says it's my property, and it was never intended that Anna would have a share in it. Anna says, actually, that's not true. It was intended to be a joint property, and I paid most of the deposit, actually, using money that was gifted to me from my parents. Christoph has changed the locks because it's his property. He's legally allowed to do so, and Anna has been forced out. Christoph has put 5 Snowy Lane on the market, and in the interim, Anna is struggling to afford private rent. I don't think we've actually written it here, but I think for the purposes of talking through it, we've said that really the children are spending time between the two of them, but Anna's the primary carer for them, so they're spending more time with her. So what are your potential claims here? We've got TOLATA and Schedule 1. She's got the TOLATA claim by virtue of the fact that she paid most of the deposit monies. As Tara spent time explaining earlier, that should be evident from the conveyancing file and or from her bank statements. She might be able to prove email documentation where she says to the conveyancing solicitors or the like, hello, here's the document, here's the deposit that I've provided. If she provided it to Christoph, you're definitely going to need bank statements because it may have been that she sent it to Christoph. Christoph then paid the conveyancing solicitors and all of that got done in that way. But if it's been agreed between the parties, which it might be, you never know, when you're doing the disclosure by list, etc., if it's been agreed that Anna actually did pay the deposit on the property, then she's got a TOLATA claim by virtue of the fact that she supported the initial purchase of the property. You would then probably need to have a degree of discussion about what percentage that accrued her in the property. So again, it's probably a Part 7 claim dealing with a declaration of beneficial interest for Anna, depending on the amount that that deposit would represent in terms of the interest in the property. But also, she's probably got a Schedule 1 claim on the facts of this. She may well have a Schedule 1 claim in relation to maintenance. She probably, almost certainly, has a Schedule 1 claim in relation to housing if what she receives from the TOLATA side of things wouldn't be enough. And so what are the next steps that need to be done? So the first one, and probably the most obvious, is whether Anna could put any sort of restriction on the land registry title to try and prevent Christoph from selling the property or completing on the sale of a property. Freezing injunctions do exist. But they are just obviously under different pieces of legislation. So there's no specific freezing injunction under Schedule 1, but there are freezing injunctions under Part 25 of the Civil Procedure Rules, Practice Direction 25A, and Section 37 of the Senior Courts Act 1981. Flagging up the interim issues here, as Tara just raised in the last 2 slides ago. In relation to maintenance, she may be in top-up jurisdiction, and so she may need to apply for interim maintenance and also a costs allowance. We don't know what Anna's saving situation is, but it may be that she doesn't have enough to make the application on her own without that. Still think about an early Part 36 offer. That may be something that's actually particularly crucial, given that the TOLATA aspect will probably need to be resolved before you go on to the Schedule 1, because of the fact that you'll need to know what, if anything, Anna's getting out of 5 Snowy Lane before you then move on to look at what she would need in addition or to top up in relation to Schedule 1. And then I've put occupation order at the end. This is not a talk about occupation orders, but it seemed to us that some practical advice for Anna may be thinking about an occupation order. Maybe not if the property is nearing a degree of sale, that being finalised, but it's something certainly to think about given what seems to be, for Anna, a particularly vulnerable situation. So what do you do next? Well, if you were acting for Anna, you would issue both applications, and you can't let really one set of applications run their course before issuing the counter application. You need to issue them at the same time. That doesn't mean to say that the court wouldn't need to determine the beneficial interest prior to then looking at the Schedule 1, but they could run concurrently alongside each other, and the court would want to be informed. Well, one would inform the other, basically. If the TOLATA application has been issued first in the county court and then the other side want to counter it with a Schedule 1, so say Christoph's running ahead with his potentially an order for sale, etc., then you would potentially want to counter that with a Schedule 1 if you're Anna, or you'd want to counterclaim in respect to the TOLATA. then you might need to remedy that by writing to the court. But also, and this is a really crucial point for practitioners in London, it's got to be issued in a court that can exercise both the family and the civil jurisdictions. This poses a bit of a problem when you look at the CFC and the Central London County Court, because of course they are completely divided. So you would need to make sure that you're issuing in a court that's got a judge that's available to do the ticketing for both of those applications.
And we just wanted to touch on a little bit of the procedure, because as Samara says, if you've got a case which is going to involve both Schedule 1 and TOLATA, you want to get both claims issued straight away. And the rule as set out in W&W, Joinder of Trusts of Land Act and Children Act 1989, applications 2004 case, is that those applications should be heard together. However, as we will see, they should not be joined together. They're listed alongside each other so that the same court can hear them at the same time. But given the differences in the rules, acts, etc., it would be wrong and unsuitable for the claims to be consolidated together. That's probably going to be more relevant to counsel who's or instructor solicitor who's drafting each directions order, to think about when you are drafting. And a point that we'll go on to say is that it's, can I just move that box? Sorry. Is that they will normally be heard with the FPR sort of process. So what we tend to find is that actually when you've got one with Schedule 1 included, you're having the first appointment, you're having the FTR, and then you're having the final hearing, even though it's both claims. Now, one of the things that I always think tactically is a good idea to think about is, do you list it as a separate hearing, preliminary hearing to determine the TOLATA issue, or do you lump it all in together and have one big final hearing? Now, in this case, so going back to Christoph and Anna, if Anna had a really strong case on the TOLATA point, let's say she had
all of her evidence checks out.
All of her evidence checks out, and she had her evidence that she paid a huge amount of deposit, and then there were conversations with the conveyancer, then you would want to get the TOLATA claim heard separately and in advance to give her the very best cost protection. Because we all know the usual rules on TOLATA claims: costs follow the event. And let's say she'd made some really generous Part 36 offers that she thinks she's going to beat. She'd get those costs on an indemnity basis, rather than it all being fudged, if you don't mind me saying, into a more family sort of approach at a final hearing. So I definitely think about split trials, if there are the resources available when you've got a really strong TOLATA case, because it can also tip the other side then into then making, they don't want to be bruised twice, tip them into then making some really reasonable offers. Point we've just set out there is, just because the sort of procedure is the family procedure, it doesn't mean the CPR doesn't apply. So always be thinking about your Part 36 offers. Always be thinking about getting evidence in time. Relief from sanctions would need to be applied for, and we know that they are a lot stricter on those procedural matters in the county court.
And don't forget, this is probably more of a point for us than perhaps it is for any solicitors watching, but the orders need to be drafted separately. They're separate orders. You should not be putting, say, for example, you go to an FDR that's been set up in Schedule 1 and TOLATA cross applications, and you agree that there will be a deferred order for sale in 5 years, but pending that, one parent will stay in occupation of the family home to the exclusion of the other, and you've agreed various other terms that might go on the Schedule 1 order as well as that occupation, then you're going to want two separate orders. You've got to have the order for sale under TOLATA in one order, and then the exclusive occupation and any other Schedule 1 bolts and whistles that you've got on in the separate order for that. But they do need to be two separate orders. And then lastly, we've got case study 3. So again, forgive the Disney theme, but we've got Snow White and Mr. Dwarf. They've been in a relatively short relationship of only 3 years, but they've got a 1-year-old baby named Sneezy. Mr. Dwarf runs the very successful fashion label Tall Sally. So he's got quite significant resources, quite a significant income. Snow White doesn't work. She fell pregnant, and then it was decided between them that she was going to be a full-time carer for their baby. The parties live at Magic Mirror Manor, which has basically an estimated worth of about 5 million, but it's something that Mr. Dwarf inherited from his uncle about 10 years ago. Snow White says she paid about 35,000 towards the mortgage on Magic Mirror Manor that Mr. Dwarf subsequently took out on it, on the understanding that she would have a share in the property. But Mr. Dwarf says, no, that's not true. You were only paying me rent. And he thinks he's got an email to prove it. You haven't actually seen the email, but he thinks he's got this email. So what are the possible claims here? Schedule 1, I think, likely to be very strong, given that Snow White isn't at work. The parties agreed she'd be a stay-at-home mother, and Sneezy is still very young. You're not likely to find a court that's going to suggest that she should necessarily be going back into full-time work if that isn't what she wanted, and particularly where it seems there are the resources for Mr. Dwarf to pay her not only top-up maintenance, but perhaps the Hexa, as we spoke about earlier. Those particular maintenance issues are likely to be quite important. But this also may be a case, depending on what the resources are, where Mr. Dwarf could either take out a mortgage or could provide the capital resources for Snow White to be housed, either have a house bought for her outright that would revert to him on Sneezy turning 18. But these are the sorts of things that you need to think about. Likewise, any additional capital claims that would be important for the baby as the baby grows older. TOLATA has a pretty low prospect of success. I think Tara and I would agree, given that £35,000 is a very low value of the contributions that she says she has made to the total value of the estate. And proving that is probably going to be disproportionate to the value of the claim. You're more likely, or certainly I think Tara and I would be far more likely to say, look, you've got a far better prospect under Schedule 1, focus on that, let's put together your needs plus shopping list and everything that you say is required for you and Sneezy, and we basically put our focuses there. So as I've said at the bottom, you need to then have tactical discussions about where you pitch needs. I sometimes think this is one of the more difficult things under Schedule 1, because you're not going to want, and the court's not going to want, children going between one parent that's got an extremely lavish lifestyle and one parent that can only afford the very lowest level of the properties that are available on the market in the particular area that they live. But neither is Snow White entitled to any degree of sharing. It's not a sharing jurisdiction. It really is based on needs plus. But as we said at the beginning, it's all got to do with needs around the children effectively. But when I have usually a conference before a Schedule 1 first appointment and I'm acting for the applicant, usually the mother, not to be gender stereotypical about it, I like to sit down and say, can we actually pad out what your needs are now? So that either an open offer if you're particularly confident about it, or as we can see on the next page, I've put there on the penultimate bullet point, without prejudice save as to costs offer. That jurisdiction is still available in Schedule 1 proceedings. You can still make without prejudice save as to costs offers. And my preferred tactical route really is to make that offer as early doors as you can, given it's more of a needs-based jurisdiction. It should be fairly obvious what your client requires in terms of their housing, in terms of their car needs, in terms of the child's potential school fee needs, in terms of anything that they've got potentially arising from a disability, any educational needs, all those sorts of things. It should be relatively easy to set all of that out, very open doors. And what I like to do is make that offer, and then effectively just sit on it. So that you can say, well, we've made our proposal. It's really up to you, the respondent, to have a think about you making a counter proposal. Most of my Schedule 1 cases, the applicant has been awarded a costs allowance. So it puts even more pressure on the respondent in terms of their engagement with the proceedings, because if they're the one that's paying for the proceedings to take place for both parties, then it puts even more pressure on them. So I'm a big fan of an early offer in Schedule 1. I think it works tactically very well. But as it says on the slide, this really should be home ground in terms of the procedure for family practitioners. Schedule 1 is family business, and so it falls under the FPR and FPR Rule 9. And the litigation structure is the same, really, as Matrimonial Causes Act application. So you've got the first appointment, the FDR, and a final hearing. You use Form A1 to issue, and as Tara dealt with earlier, Form E1 is the usual form for a financial statement. But if you've got particular reasons why you would want to use Form E, such as properties being owned by companies and not being able to establish the true wealth position of a respondent, then you might say, look, a Form E is more appropriate in these circumstances. And then we've got the different types of offers that can be made. And of course, it's usual rule, or clean sheet rule, actually, on costs.
We hope you found it informative. And please do drop us an email if we can help. Obviously, we can't give advice on on any individual cases, but if you want kind of anything on principles and tactics, we are more than happy to help. Thank you very much.